Thank you, Sue. Hello, everybody. Well, I've just come from another webinar talking about the new the new rules coming in on Monday next week, bringing more and more people to mediation, and of course that's going to mean that more and more children are taken outside of that court process and hopefully come to the attention of mediators. So hopefully this today gives you a little bit of a background of what might be coming next. So looking at the law first, there are a number of pointers that we have in terms of the guidance on bringing the child's voice into arrangements that are made for them. Article 12 of the United Nations Convention on the Rights of the Child says that children should be, and I've put it the text there for you so that you can all see moving forward, but basically children parties should assure that the child who is capable of forming his or her own views the right to express those views freely in all matters affecting the child. The views of the child being given due weight in accordance with the age and maturity of the child. And they mention that for this purpose, the child should also be provided with the opportunity to be heard in any judicial and administrative proceedings affecting the child. That's very much the guiding light for child inclusive mediation. That's our steer. Article 8 of the European Convention on Human Rights, that also says children should have the right to attend a court hearing where the case impacts on their rights to family life, further reinforcing the rights of a child. Other areas of law that govern this area in the UK, the Children Act specifically deals with the welfare of the child, and all courts have to be minded to consider these points. So when a court determines any question with respect to the upbringing of a child or the administration of a child's property, or the application of any income arising out of it, the court should have regard in particular to the ascertainable wishes and feelings of the child concerned. So ascertainable obviously is not necessarily stated, but it's understanding how to bring that child's wishes and feelings into proceedings, and the definition of parental responsibility is also defined there. Family procedure rules, updating this in 2010, is very, very clear about what we should be considering when children and their rights and their wishes and feelings are being considered by courts. Children and young people should be at the centre of all decision making. This according to the Family Justice Young People's Board and their charter. The children should feel that their needs, wishes and feelings have been considered in the arrangements which are made for them. And the children should be involved to the extent which is appropriate given their age and level of understanding in making these arrangements which affect them. And this is relevant whether it's inside or outside of the court processes. I suppose the problem at the moment is that the focus of the Child Arrangements Programme is on early settlement and streamlining processes. It's not keeping children and their families in the court arena longer than necessary. So it directly prevents, therefore, CAFCAS or CAFAS Cymru from meeting with children before a first hearing. And so if a settlement's reached within court proceedings, there is no mechanism available under the Child Arrangements Programme for children to have their wishes and feelings directly consulted and heard. So there have been a few reports that have come out in the last 6 months, which are very much challenging the status quo in terms of how we listen to a child's rights, given that the law says that the children need to be their wishes and feelings need to be heard. Basically, we're all at a point where we realise that that's not actually really happening. So it's a common refrain in private law proceedings that the proceedings aren't about the rights of parents, but about the rights of the child. The clear implication is obviously that when caught up in their own emotions, parents might not properly listen to their children to promote their welfare. The report starts from the same understanding that children have the rights that need to be promoted and protected, but it asks a different question. It asks the question, how well is the family justice system following its own instructions and promoting children's rights to be at the centre of decision-making about their lives? And the answer isn't terribly positive. It reiterates previous findings that in many cases children's voices appear to be entirely unheard in private law proceedings, but starts to ask a few more questions to look at what is happening for children and what we need to do to improve the circumstances. Perhaps the most surprising finding is how little impact age has on whether children are provided with opportunities to be heard within proceedings. So a 2-year-old and a 14-year-old, they statistically, it will go on to tell us statistically have a similar likelihood of being heard when arrangements are being made for them under the court process. So the Family Justice Observatory, they looked at levels of participation of children within court proceedings. And they said around half of the children, slightly more in England than in Wales, had at least one marker of participation within 3 years of the case starting, or the application for to the family court. This means that for almost half of the 67,000 children in England and Wales who were involved in private law cases starting in 2019, there is no indication that they participated in any way in their case. The most common way in which children participate is through a Section 7 report. But that tends to be where the court has already highlighted that there is an issue that needs to be explored by CAFCAS or by social services. And only 5.2% of children in England and Wales had more than one marker of child participation such as this. So the Family Justice Observatory came up with a few reflections on what that means for children in today's world in the UK. Obviously, within private family law proceedings, the family courts are making hugely important and potentially life-changing decisions about a child's life. If a child's right to participate in those proceedings isn't happening when decisions are made by them, then we're going against domestic and international law. The study found that around half of the children, including older children and teenagers, didn't have any indicators that they're being consulted directly. And it's highlighted the fact that the welfare reports and the appointment of a children's guardian are the primary vehicles within the court process for children's participation in proceedings. So, and these orders, these reports can't be ordered until the first hearing. So it's not possible to consult with a child before parents are already in court within the court process. So there's no universal mechanism for children to express their wishes and feelings, despite the hugely consequential nature of these cases. I suppose what we're starting to notice as accredited mediators is that the courts are now starting to steer cases back to mediation where there has been deemed to be no requirement for a CAFCAS Section 7 report, that there are no safeguarding concerns. So quite often, as mediators now, we're seeing more and more cases coming back to mediation where a court has steered the parents to come to mediation, and they've mentioned child-inclusive mediation specifically in their interim court order. Further reflections from the Family Justice Observatory. The relatively low level of increased participation by age may simply reflect the fact that it's only if there are safeguarding concerns that there is any trigger to have any consideration of the welfare of a child within the court proceedings. So they suggest that a child's right to participate and the weight of importance of their wishes and feelings in the light of their age and understanding is not being fully reflected in the current system, which just doesn't offer routine involvement even for older children outside of these primary routes. Also, the Family Justice Observatory found that the proportion of children who participated in proceedings varied by court area. So that needs more exploration, but quite often the level of deprivation might feed into the number of court hearings in any particular area, and that might be a bigger indicator of whether a child's wishes and feelings is heard within the court process. So the challenge for the family justice system as a whole is to reflect on the changes needed in policy, practice, and in resources to ensure that mechanisms are in place to give children the opportunity to have their voices heard, both to ensure the children's rights in the first place and to support the decision-making that is obviously meant to be in the best interest of the children. So again, I put at the bottom of this slide, mediation. Is this not a way forward for us? And certainly that's what we're seeing is judges are steering cases which fall outside of these welfare reports back to mediation whilst the court proceedings are still running. And final reflections from the Family Justice Observatory is just quite simply that I suppose what any child inclusive mediator would tell you is that children are absolutely the experts of their own experiences. They absolutely know what it's like to be caught between two parents. They absolutely know what it feels like to have to drive a long way for an hour's contact and drive back again, or, you know, all of the many things that the parents might be discussing, whether in court or in mediation or elsewhere. The research has also shown, and this is research findings produced by the Family Justice Observatory, that that children are more likely to accept the decisions made about their living contact or other arrangements, and to have a more positive experience of the ongoing relationships with their parents when they've been involved in the decision-making process, which is obviously very different from saying that they should be given the choices and the decisions themselves. So recent research in Wales found that participation can improve children's experiences of private law proceedings through building trust in professionals and empowering the children, obviously, in a proportionate manner. And having a voice in matters that concern their welfare has also been found to promote children's well-being. Just having the opportunity to talk to someone and feel heard has been found to be beneficial to children, even if that doesn't have any tangible impact on the decisions that happen next. There's no statutory requirement to consult children directly in private law proceedings in England and Wales. So, so at the moment, children are rarely present in court, so their wishes and feelings tend to be presented by the adults. Children have been described as, by and large, comparatively invisible in court. And a recent review of international research of children's experience of parental separation and court proceedings found that children overwhelmingly do not feel heard and have a limited understanding of the court process, the role of lawyers and judges, and their right to be heard. Children do not generally understand that the United Nations Conventions on the Right of the Child exist. They're just not aware generally. And although there were positive experiences, some children expect dissatisfaction with how they were involved in court proceedings and decision-making after parental separation, and felt that their voices and views were not prioritised, which is consistent with other studies abroad. So what next? We are in I suppose, a moment of change in many areas of the family justice system. And I suppose that, you know, it's worth noting that there have been calls from the Family Justice Young People's Board. They're children who've been involved in the family justice system and are trying to feed back into CAFCAS their experiences to help with policy decisions. The Justice Working Party on Access to Justice for Separating Families, the Family Solutions Group I'll mention shortly, and the Domestic Abuse Commissioner. They've all called for a more child-centric family justice system with children directly involved in decisions made about their lives. But that isn't the status quo at the moment. So I suppose one interesting development that has been running since early 2022 is the pilot, the Pathfinder Courts, which is a pilot a pilot operation at the minute, which does look to be rolling out to further areas, but certainly not nationally at this stage. The interesting experiences that that have come out of that pilot is that it takes a problem-solving, domestic abuse-informed approach to dealing with cases involving disputes between parents. So it does still have, as under the Child Arrangements Programme, this intentional goal of supporting resolution by agreement where appropriate as soon as possible to reduce the delay. But this model explicitly focuses on ensuring that the voice of the child is heard. There is a child impact report that is written by social services at the start, not necessarily because there's a safeguarding concern. And this provides for engagement with the child before the first hearing to determine their circumstances, preference for engagement, and their wishes and feelings. Hopefully, as we say, that I think what the feedback from these these two pilots is that professionals work together a lot more, and so you know, the cases might be referred to mediation. There's just much more of a collaborative approach across the different professions. So moving on to the Family Solutions Group, their second report that came out at the end of last year, A Child's Right to Matter. They start with, their report starts with some quite stark statistics in terms of how many children are affected by family separation and how very few of them at the moment are directly consulted in any way. So their question is, who in government takes responsibility for children when parents separate? And basically, as you can see there are many different government departments, none of them specifically responsible for the holistic view of the family, and particularly of children when their parents are separating. So the Family Solutions Group, a multidisciplinary group set up by Honourable Mr. Justice Cobb, was to consider what we need to improve children's experiences. Their first report, you might all have heard about it, the What About Me report in 2020, was the basis on which they've conducted 2 further consultations. One with a cross-section of experienced multidisciplinary professionals, and the second with 112 members of the UK Youth Parliament. So that's children aged 11 to 18. And so they've looked at the common themes that seem to have come out of children's experiences at the moment of their parent separation, and how they feel heard when they are also going through that experience. So there's a number of things that are said. I won't read every single one out to you, but certainly they're there to read at your leisure. But basically, children feel that the vast majority of professionals don't understand them. It explains that it's normal for children to be affected by family separation, and how children are affected can absolutely be determined by the process and how it's managed for them. Parents are not always the best judge of how their children are coping. Obviously, parents, we as mediators, speak to both parents at the same time, and obviously we're aware that parents have got their own struggles that they're dealing with, whether that's emotional struggles, psychological struggles, obviously financial implications of the separation, and generally have an awful lot to try and work through themselves. So it's not unusual for parents to miss what's happening for children, and it's not unusual for children to feel that they can't burden their parents with their own experiences. What's come out of this report is that children need information and support to help them navigate family separation. But they don't know, they're not aware of who they can turn to. They basically said that they would probably turn to teachers, family members, but they're not really aware of their rights, and there's no obvious sources of information. Most children can cite Childline as a source of information, but nothing more. It's interesting to note that children need access to a listening ear, not necessarily to counselling or specialist support. That might be required as well, but sometimes just someone to listen and a person they can talk to. And outcomes for children are better when they're consulted about arrangements. And I suppose I should stop and pause and say this is, of course, part of what child inclusive mediation is. The role of the mediator is first of all to listen to a child's experiences. It is also to help the child to work out what they want to report back to their parents, but a child doesn't have to report anything back, and if that's the case, then there would be no feedback to parents. It's also just as the MIAM is for their parents. It's a confidential conversation where the mediator can pass on information. So in many ways, child inclusive mediation, although rarely used at the moment, absolutely does perform these roles that are being highlighted nationally at the moment as being something that's not being provided to children. A few more. I won't read every single one of those out as well, but it's probably helpful just to have the different findings that came out of this information, as some of it I've mentioned already, such as children didn't know that they had a right to information. Children basically, what this report has highlighted is that children are just they feel that things are done to them, and they don't feel they have any say in the experiences, and aren't aware that certainly aren't aware of the law around this situation, that they have rights as much as their parents do. So the Family Solutions Group made a few recommendations for government. Again, there's a lot of information in this this slide, which you might, and the next couple of slides, which you might want to sort of look at later if it's of interest to you. But it's basically saying that we need some we need to establish information for children first of all. Often schools is a good neutral space, so just making sure that information is at schools for children would be helpful. We need to establish mechanisms for children over 10 to be offered consultation so that their views can be can be considered when decisions are being made around them. This, of course, again ties back to child inclusive mediation, which indicates that the FMC standards point out that children should be offered child inclusive mediation, at least from the age of 10, and below the age of 10, very much on the in terms of their Gillick competence and their their ability to form their own understanding of their circumstances. So family hubs would be helpful. And far more information for children. Also, the recommendation is to incorporate the United Nations Convention on the Rights of the Child into domestic legislation as a matter of urgency, in accordance with the UK's commitments as a signatory. Obviously, given our current I suppose our current political stance on any form of human rights, that's something that's a conversation that will run on for quite a while. So I say as in our governments. So more recommendations for government. We need to make sure that all children have and not just children with Section 7 reports looking into their best interests, need to be able to speak to a professional. Providing more information, again, schools, developing PSHE information on parental separation, and training the first responders, almost the people who tend to see children and are likely to spot children who are struggling, perhaps. One of my colleagues at the Family Mediation Trust was a former teacher, and she said that you would always know every year there would always be 2 or 3 children in a class that you knew were struggling with their parent separation. I think it's visible to teachers, but it's not really their responsibility to obviously take that upon themselves, as well as educating children. But if we're able to provide them with the knowledge or with the information that they can refer children to, then that will obviously be part of the safeguarding team's role at school. So, child inclusive mediation, the reason for talking about this today. I hope it's sort of clear when I've referred to it as I've gone through that child inclusive mediation addresses most of these issues that are being highlighted as shortcomings in a child's rights being addressed when their parents separate. As mentioned earlier, we are noticing more and more courts referring parents to mediation where there's been no CAFCAS involvement. In those cases, of course, some damage has already been done if an application to court has been made and parents are making allegations about one another. We find these can be some of the trickiest cases, and in a way, if we can catch parents before they get to that point, in the cases where there are no safeguarding concerns, then the support to parents to consider what's happening for their children comes earlier. I mentioned FMC standards, the Family Mediation Council. There are standards for child inclusive mediation training. So when a mediator trains and becomes accredited, they're not automatically child inclusive mediators. There's a further training that we need to undertake, and that addresses much of the information that I've given you today about a child's rights, first of all, the confidentiality that's extended to children, and just making sure that you first of all are listening ear, and secondly that you can provide information as well as conducting the practical steps of child inclusive mediation, of working out with the child what they may want to feed back to their parents. So the basis of child inclusive mediation is the same as it would be when both parents attend the MyAM assessment meeting. The child and young person participates voluntarily; they can't be forced to do so. And if a child doesn't want to, then they wouldn't be required to. Before the child currently, before the child is offered child inclusive mediation, both parents have to consent. It can't be child included mediation can't be ordered by the courts, but courts do steer parents to consider it, which is effectively the root of requiring a MyAM. It's to encourage people to be able to speak to a mediator, to explore with a mediator first and foremost whether the mediation is going to be suitable for them. Confidentiality. The child is offered the same confidentiality that their parents are offered at the MyArm. It's exactly the same set of circumstances in which nothing is reported back unless there are safeguarding concerns, and it has to be made clear to the child at the start. There are exceptional circumstances where a court maybe would impose an overriding obligation of disclosure upon the mediator, but that's extremely rare. And mediators must ensure that they've explained the confidentiality to the child, first of all. Impartiality and neutrality as to the outcome. The mediator must remain impartial in the meeting with the child or young person and must remain neutral as to the outcome of the mediation. The mediator doesn't represent the child or act as the child advocate. The mediator's role is very much to report what the child wants to report back and not to put any analysis on that or any statements. I mentioned information earlier, and I suppose the final point that a mediator would always point out to a child is that the decisions remain with the child's parents or whoever holds parental responsibility. It's important for children to be able to discuss their wishes and feelings, maybe make requests, offer suggestions, but they're not asked or given the power to make choices or decisions because they're not adults, and that would not be in their best interest. So the conclusion from the Family Solutions Group is very much that the children of separating parents are affected by the separation, just as their parents are. They won't be having the same experience as either parent, but they are absolutely as affected as their parents are. Their needs and rights must not be overlooked, either by government or by family justice professionals or by schools. It's not enough for government to focus on early resolution methods for parents without acknowledging the gap in provision for children, and this, of course, is where mediation can come in. Some simple measures are needed to provide information, resources, and a listening ear to children. Again, that's something that can be provided through child-inclusive mediation. And there's also a need to establish mechanisms for children over 10 to be consulted as the expected norm following parental separation. That is, I suppose, the new change, the new shift in the mediation world is rather than, I suppose it's almost like the donor card option of when you opt in to maybe being sort of a donor, there's a small uptake. I guess that's the same at the minute. There's a small proportion of mediation cases involve the child being directly consulted, but the recommendations are that certainly within mediation that it's the norm that children are consulted rather than the exception when parents are in disagreement or feel that they need to find something out from the child that the child isn't saying. These measures will hopefully over time lead to savings across multiple government departments, but more than that, of course, the sooner two parents can be supported to be able to put the needs of their child first, the better that everybody in that family is going to fare. And hopefully, I suppose the thing that all mediators know is that the sooner you can support parents to reduce conflict and to be able to put their children's needs first, to be able to address their children's concerns, but still hold joint decision making, is going to build resilience and improve childhood experiences for the children. And that is a large number of children affected by family separation each year. And that is the end of my my presentation. I'll get rid of the one there, and I don't know if there's anybody who wants to ask any questions or any thoughts.
Belinda, I've got a question, if that's okay.
Sure.
It was fantastic, by the way. Really enjoyed hearing all about that. I have a question just with a focus on schools. As a teacher for many years before coming into this role, when I was teaching, I never had any CPD about how to support children in my school or my class who were going through a separation. As a governor more recently, absolutely no training again. I've recently developed a 2-hour Twilight CPD session for schools, knowing how important it is. And all the research that's coming out that you've highlighted, and this sort of need for children to be involved in a slightly different way, and the way that schools just can offer that signposting, if nothing else. And there is a resistance. There is a resistance for schools. Very much the response that I'm getting is, we have this covered. I don't think I have come across a single school that has a policy in place which says, if we have a situation where we have a child and we have parents, parental responsibility, and they're arguing, or children's going on residential, one parent signs the form, one turns up and says they can't go. Schools are not prepared for this. I just don't know if you have any wise words or place I can go for maybe statistics, something I can really hit them with and say, come on, like it's an hour of your time or 2 hours and the difference would be phenomenal.
Yeah, yes. I suppose the two reports, the Family Justice Observatory report I mentioned, so that they are back. I can certainly put them in the chat once I finish speaking now. That one and the Family Solutions Group. I think what they're saying, and the Family Justice Young People's Board, all three, that children are the resounding information coming out is that we feel unheard, and even when we go to teachers, the professionals that they generally talk to, that they feel misunderstood, and it's not necessarily it can be they also speak about their experiences within the court proceedings, but when they're referring to professionals, they're not actually talking about court professionals. They mean they go and speak to someone and parents don't understand. So it's tricky. I think there's also there's a peer-to-peer mediation. I suppose in my, when I've got nothing better to do, I've got lots of free time, I kind of think it would be good to sort of teach children to sort of almost come with some sort of CPD for teachers, certainly, but where children are taught mediation within schools. I think quite a lot of schools have taken it on board now, and so children. I think a mediator comes and trains children, and some children are the mentors in the playground, and so they sort of ask mediator questions, and when there's a dispute in the playground, and I think sometimes that can be really helpful. And I often wonder whether we can sort of tie the two together, because that's I think we always need some way of funding that for schools, and people who've taken any sort of anything into any sort of support and information to schools, it has to be provided free of charge, or it just won't happen. So I suppose that's the problem, isn't it, at the minute? But more and more, I think I was at an event recently where I was just talking about mediation, and some of the other storeholders there, one of them said, "Oh, we had that in our primary school. There is that mediation." And when another storeholder came over, they said, "Do you remember that that initiative in the playground where children help one another?" And the other parent said, "Oh yeah, mediation, yes." So I think to some extent, I almost wonder whether we have to do it through the back door. But yes, those statistics are in those two reports today, and it's a very loud call that we don't feel heard, and you don't know what to do when we come and talk to you. And,
I think we need to start a mission and getting a module put into teacher training. A 1 hour lecture is all it takes to say, this is what might be happening. This is how you look out for it. This is where you can signpost them to. So
absolutely.
lots that can be done.
I was going to say that is one of the recommendations for government, so I guess it's it might eventually come out there. I think with all of the changes in the family justice world at the minute, or the family law world, I should say, we're trying to remove the word justice, but it's because it's not really about justice, is it? But anyway, with all of these changes, I think the savings to the government are immense if we educate people, to whether it's signposting in schools, but if children feel supported, the knock-on effects down the line of their lives is considerable. But actually, just the cost of people going to court, and then the impact on everybody there, just it sort of seems like a no-brainer. But we'll see.
Yeah, thank you so much.
Pleasure. It's interesting. It's nice to to meet similar people who sort of see the same, see the same presentation.
Yeah, no, it was great. Thank you.
According to the NACC website, there is supposedly a primary and secondary curriculum-based thing about for children on parental separation. I've yet to see it.
I think there's a single lesson, Sue, if I'm right, and I never taught it when I was teaching primary. My son, who's currently in year 4, has yet to have that module. So I think that is very much it's a bone, it's a start, but we're very far off. But it is good, you're right, that it's there.
Yeah, apparently there's 2 lessons planned by Exeter University on relationship education.
Yeah.
I always thought RE stood for religious education, but apparently not these days.
Not anymore. Yeah, it's just that there needs to be more. And I think the problem, I suppose with everything, you almost have to solve a problem of theirs in order to engage. And I think they do that. I suspect there's some element of resources, and if there's a national, I think that's one of the recommendations, is some sort of national resource that we can all refer people to, but also local resources, so that when just at the very least, you know, teachers, it's obviously, you know, it's not, they're good enough to be managing on a day-to-day basis, but if there are leaflets and referrals, they would pass that forward. So that's probably an easy thing for the government to do, that, you know, we could then be all piggybacking on, but we'll see.
Yeah, apparently Parents Promise have got something in the pipeline for 2025.
Oh, yeah, more updated than me, Sue. But there, yes, the Parents Promise is where parents commit to working together as best as they can for in their children's best interest.
Any other questions from anyone else?